case briefs, and so much more. LSData's got what you're looking for.
In 2001, a case, Motus v. Pfizer Inc. was brought before the United States District Court for the Central District of California concerning prescription drug warnings. Flora Motus sued the pharmaceutical company Pfizer after her husband, Victor Motus, committed suicide 6 days after taking Zoloft, a drug prescribed by Dr. Gerald Trostler. Flora claimed that Pfizer failed to adequately warn about the risk of suicidal thoughts associated with the use of Zoloft. The central point of the case was whether a drug manufacturer has a responsibility to warn a doctor of potential hazards associated with their drug, and if the doctor subsequently is responsible for making the decision to prescribe it to the patient. During Mr. Motus's appointments with Dr. Trostler, he did not mention anxiety or depression until his last appointment, where he revealed his financial struggles and was prescribed Zoloft. Dr. Trostler did not consider Mr. Motus to be suicidal or depressed enough to see a mental health professional. Pfizer requested summary judgment, arguing that Flora did not have sufficient evidence to prove that Dr. Trostler would have made different decisions if proper warnings were given. The court agreed with Pfizer and granted the summary judgment. The court found that there was a lack of evidence to show that Dr. Trostler would have acted differently with an adequate warning, or that a reasonable doctor would have been deterred from prescribing Zoloft to patients with mild depression. In the end, the court concluded that the plaintiff failed to prove that Pfizer's lack of Zoloft suicide risk warning caused her injuries, and the defendant was subsequently entitled to summary judgment.
Case briefs, and so much more. LSData's got what you're looking for. Visit lsd.law, elevate your mind. Leave the stress of class.